Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. And what I want to cover in this video are some of the questions that you might be asked by a collection lawyer if you actually go to trial in a debt collection case. So Midland Funding, Portfolio, LVNV, those types of guys, they sue you, you answer, which is great. You get a trial date, and now you're in court, whether that's physically in court, whether you're doing it virtually through Zoom. What are some questions that you may be asked by the collection lawyer? And then we'll also go over some of the mistakes, and I'm just going to reference briefly because we have a very long video on that. And then at the end, give you kind of some bonus questions of at times where the debt buyers have subpoenaed our clients to court, and what are some things that we ask our clients on cross-examination. And this may give you some ideas about if you are there testifying, some things that you might want to let the judge know. All right, so let's get started. So first of all, unless you have a lawyer representing you and that lawyer says don't show up at trial, you generally need to be there. So if you're representing yourself, and I'll just tell you in Alabama, this is true. If you do not show up, you lose. Default judgment. It's like not showing up to the football game, the basketball game, whatever. If you don't show up, you default. Now, if you have a lawyer, then you need to find out from your lawyer, does your lawyer want you to be there? Or are you required to be there? Maybe you've received a subpoena which says you are ordered to be in court. So just check with your lawyer about that. So sort of after this slide, we're going to assume, okay, we're in trial. Now what do we do? And, let me go back to this. I have this at the bottom. We did a video on Rule 602, and that is personal knowledge. In other words, a witness is not to testify about something that they lack personal knowledge. So be thinking about that as we look at these questions that a collection lawyer may ask you and say, do I have personal knowledge of this? Because if you don't, then you're really not supposed to answer those questions. Now, normally we'd use the rules of evidence to object. We'd say, we object, this witness lacks personal knowledge, but it's also something that you can do for yourself is say, well, Judge, my understanding is I'm not supposed to talk about things that I just have no personal knowledge about. So again, you've got to know your particular judge, the custom of your court, but hopefully this will give you some ideas. So I've got a number of questions on here, and then at the bottom, let's go ahead and jump to the bottom. I haven't read. What questions are you concerned about being asked? If you want, just put those in a comment, and then I'll do some follow-up videos on this. But these are some pretty common questions. So the first one may seem kind of innocent. It just says, do you know why we're here today? But I have seen consumers say, well, we're here because your client, Midland Credit, Portfolio Recovery, Jefferson Capital, LVNV, whoever, your client bought an old debt that I owe, and now they're suing me because your client has this debt now. Well, if you say that, I mean, it's kind of like the collection lawyer looks at the judge and says, nothing further, Your Honor. Okay? So just understand, answer the question that's asked, and we'll remind you of this in the next slide, those 7 mistakes, and that's a video that we'll link to. But you answer the question. Do you know why we're here today? Yes, because we're having a trial and I've been sued by your client. Okay? Now, what about you admit that you had this credit card from wherever, Synchrony Bank? Well, if it's true, then you admit that. Yes, I had this credit card from Synchrony Bank. If it's not true, then you deny it. Say, no, that's not true. Look at the third question. You charged on this card and got the benefit of the goods or the services or the cash advance or whatever it is. And what they're trying to do with that is, first of all, establish you've used the card, but second, to kind of make you feel bad. Okay? I mean, it's like, hey, you used this card, didn't you? And you didn't pay for it. Is that the way you were raised? That's kind of the idea. And so you just have to take these questions sort of one at a time and say, do I understand the question? And let me just answer the question. So the question is, you charged on this card. Well, that's either true or false. and you got the benefit of the goods or the services or the cash advance? Well, if you did, yeah, I did. Say, yes, I did. And number 4, you admit that you owed, whatever, $5,000 on this card and you did not fully pay it off. Well, again, take that question. Do you understand it? Yeah, they're saying, how much did you owe on this card? And did you pay it off? And if you can answer that and say yes, then do that. If the answer is no, then say it. So they say you owed $5,000. Well, maybe you believe that you owed $4,800. Well, $4,800 ain't $5,000. Okay? So you'd say no. Or if you said, yes, I owed $5,000, they say you did not pay it off in full. Maybe you did pay it off in full. Well, then you would say that. Okay? And then look at the next one. You understand my client, will say portfolio recovery, owns this debt now, right? Okay? So we own this debt. My client does. Well, again, you can go back to some of our videos we've done last week or two where we talk about understanding the difference between owing a debt and the debt buyer owning the debt. So my question to you on this one, you understand that my client portfolio owns this debt. How would you know that? I mean, remember, you're only supposed to answer things that you know that are within your personal knowledge. How do you know that portfolio owns it? Well, they say they do. Is that proof? Well, here's a piece of paper that they say is from Synchrony Bank saying, hey, we've sold your debt to portfolio. Well, did they really? Who created that letter? Okay. Does portfolio still own the debt? How would you know this? And this is an example I've used probably for, 15 or 16 years where, so on this video or if we were doing this by phone call, I would say, swear under oath, what color socks am I wearing right now? You know they're black. Admit it. Well, how do you know? You don't know what color socks. Maybe they're white. Maybe they're blue. Maybe I'm not wearing any socks at all. Point is, you don't know that. You're not supposed to guess or speculate or just make stuff up. You're supposed to answer things based on personal knowledge. Do you personally know that portfolio recovery owns your debt? If you do, then you can answer that. If you don't, you would say no. Okay. Now look at the next one here. And we've talked about this some in recent videos, a bill of sale. Let's say, look at this bill of sale. I'm going to mark this as Exhibit 1. Look at this bill of sale. Tell me why you think it is not accurate. Okay. Well, that puts a lot of people on the spot. Like, well, I don't know. But you're looking at this document, okay, this bill of sale, and they say, tell us why it's not accurate. Well, the first thing is, if on here it references the purchase agreement, you say, well, this isn't the complete document. I would need to see the complete document to understand this, okay? Because it'll also talk about the accounts listed in Exhibit 1, typically. Well, where's Exhibit 1? Let me see all the accounts listed in Exhibit 1. And they'll say, oh, well, I'll show you this one thing that's got a bunch of stuff blacked out, and this is your account. This is Exhibit 1. Well, I don't know. Is that Exhibit 1? And what does the purchase agreement say? I mean, this says it's part of the purchase agreement. So let me see the purchase agreement. If you remember, that's the completeness doctrine that we've talked about a lot. So then this next one, read this affidavit of ownership. Tell the judge every reason you think this is a lie. Give all of your evidence. Well, so you're looking at this affidavit, okay? Then first of all, you need to understand for your court, can you object to an affidavit? Typically you can. And you're looking at an affidavit and say, well, I don't know who this is. I have no idea if this is legitimate or not. Remember we did a video recently on an LVNV affidavit. It says, I'm an authorized representative of LVNV. Well, what does that mean? Do you work for LVNV? Do you not work for LVNV? And they just start sort of reciting formulas. I have personal knowledge. Well, what's your personal knowledge? Well, these are all kept as business records. Well, how are they kept? Okay. Well, we bought the debt. How did you buy the debt? So with an affidavit, you don't have to prove that that's a lie. They have to prove that it's accurate. And just reading through this affidavit, how would you know that this is true? Again, remember, personal knowledge here. And then look at this last one here. You know that, I'm going to give you an example. This is from years ago, but you can kind of use different examples. You know that the AT&T Universal card merged into or was bought by Citibank, and that's who owned your debt before selling it to my client, LVNV Funding. Well, do you know that this company merged into this company? Maybe you do, maybe you don't. And see, it's not always 100% usually. So they say, well, you know that Bank of America bought this old credit card, this previous credit card company. Well, I don't know. Did they buy it? Did they buy all of it? I mean, that's evidence that they need to put forth unless you personally know this. And my suggestion to you is, seeing something on CNBC or reading it on Yahoo News or Fox News or CNN, that's not proof that it really happened. That's just somebody saying something. That's really hearsay. Okay? So I would not just, agree with them when you don't truly know. So they go, well, you know that Capital One bought this from HSBC. I don't know. Did they? Did Capital One buy this from Synchrony Bank? I mean, the lawyer's suggesting it, but is the lawyer's suggestions, are those questions the same as evidence? They're not. When we do jury trials, the judge will say, before we get up and do an opening statement, say, ladies and gentlemen of the jury, what the lawyers say to you is not evidence. It's just what the lawyers say. Okay. Evidence is from this witness stand where somebody's raising their hand, and it's also documents which are received into evidence through a witness on the witness stand or some other means. So the lawyer just saying, well, now we all know that this company bought this. I don't know. And then notice at the end of it, before selling it to my client, LVNV Portfolio, Midland, Jefferson Capital. Well, again, how do you know that without seeing the purchase agreement? So I mentioned this before, but definitely any questions that you're worried about, you say, oh my goodness, I hope they don't ask me this. And this is a technique that lawyers can use also when we're trying a case. We say, what would be like the worst thing that could come up in trial? Or what do I hope that the other side doesn't ask? Well, that lets you know your vulnerability, so you've got to fix those vulnerabilities. Okay, so it's not bad to have those feelings. That tells you what you're concerned about, and then you go fix it and you prepare yourself. So again, if you have any of those questions, let me know. Now, I'm not going to do this whole video because I think it's like a 35-minute video, and there should be a link either in the description or in this video. But 7 mistakes. So let me just run through these real quick. Number 1, guessing instead of testifying based on personal knowledge. Number 2, answering a question without fully hearing it. If you don't hear it, how can you possibly answer truthfully? Number 3, answering a question that you heard, but without understanding either the question as a whole or each individual word of that question. Number 4, answering a question without first taking a moment to think about the truthful answer. So the question comes in, you go, I heard it and I understand it. Now let me take just a moment to answer that truthfully, rather than just making a snap answer and then going, oh, I answered that wrong. I mean, this is not a contest, okay? Not like Jeopardy where you have to buzz in or something. This is, be deliberate about it. A question's asked, I hear it, I understand it, let me think about it, and then notice the 5th one, answering more than is asked. Instead, only answer the question that's asked. So we could think about, it comes in, I hear it, I understand it, let me think for just a moment. Now, only answer the question asked. Okay? Did you have a great weekend? Yes. Now, this is not an everyday conversation. This is an interrogation. You don't volunteer stuff. Okay? So, did you have a great weekend? Yes. What did you do? Well, now you can explain what you did. But what we do in everyday conversation is, did you have a great week? Oh, yeah, let me tell you what I did. Well, that's not a great way to answer questions in court when you are being interrogated. Okay. Number 6, mistake is trying to outsmart the collection lawyer. oh, she's asking me this, so I'm going to answer it this way to kind of no, don't do that. She's asking the questions, you answer them truthfully. Then number 7, just having the wrong courtroom appearance, and this is true in Zoom also. I mean, there's an article written about one lawyer showed up to a Zoom trial without wearing a shirt. Another lawyer showed up, she was still in bed and she had the covers pulled up, and it's no, don't do that. Dress appropriately for court, dress and act in the right way, show up on time. Again, we cover all these things in our 7 mistakes video. Here's some bonus questions. So years ago, collection lawyers used to subpoena our clients to trial because they would show up without a witness. And they're like, well, if we have John's client there, then we'll win. Well, again, I would prepare my clients for this, okay, kind of like we're doing here. And then here are some questions sometimes I would ask my client just to make a point to the judge. So I'm going to run through these very quickly here. You ever borrow any money from the plaintiff being LVNV or Midland or Portfolio? Obviously, the answer is no. You ever buy any products or services from the plaintiff? No. Plaintiff ever fix your car, your AC, your roof? Ever loan you money? No. Okay. Did you ever hear of the plaintiff before they sued you? Now, if they had, I wouldn't ask that question. Okay. But a lot of times people say, the first time I ever heard of this company, particularly if it's a company that does not credit report, like Unifund, they typically don't credit report. We literally, first time you hear of them is when that sheriff hands you the lawsuit papers. Okay. Did you ever agree to do business with the plaintiff? No. Did you ever agree that you owe money to the plaintiff? No. Have you ever seen any proof the plaintiff owns his debt? No. And then the final question, do you owe the plaintiff any money? No. Now, again, that's kind of rapid fire, okay? And the judge understands what's going on. And now the judge is faced with this situation where the plaintiff, the one suing you, hasn't put forth proof. You are saying, I don't know who these people are. I never did business with them. They never gave me anything, never sold me anything, never made any repairs for me. I never agreed I owe them. I never agreed to do business. And I certainly do not owe them any money. And then that makes it generally very easy for the judge to rule in our favor. So obviously, if you're doing this on your own, you have to know your judges, your court, your rules. If you have a lawyer, talk to your lawyer about it. But these are some things that have been helpful for folks that we represent. And then also folks in Alabama that are representing themselves. A lot of times I'll jump on a call with them and we'll kind of go over this because I want them to win. Because remember this, when you win your trial, really, really good things happen with credit reporting and maybe with the ability to sue the debt buyer that sued you. Those are fantastic, fun cases. So I appreciate you watching this video and I'll talk to you in the next one. All right, see you tomorrow. Bye-bye.